Okay, David, as you have a career as a lawyer and barrister, can you tell us about legal interpretation in judging?
Well, you asked me to do that as a kind of follow-up of my career as a lawyer and to kind of extrapolate more generally, because I've written about qualities needed in a judge and qualities needed in an advocate. And I've written about questions of the interpretation of text. And I've written something recently about it, which hasn't formally come out yet, but it's an expansion of something that's been much cited that I wrote in the Irish Bar Review and in other institutional publications on the question of the historical interpretation of the Constitution. But it may seem technical, so this is a kind of a technical rather than a thing, but technical arguments often have political undercurrents to them. So, for example, if you look at questions of strict in Britain or Ireland statutory interpretation, how do judges go about interpreting a statute? Well, the first rule of call is that, and it's also a constitutional interpretive point, and you asked me about this, is that they look at things literally. What are the meaning of the words of the statute? If the meaning is clear and unambiguous, then we just simply apply that meaning to the case at bar. The problem with this is words are capable of different and opaque meanings, and what may seem clear to one person is far from clear to somebody else, and that creates a sense of latitude. And the great political and legal philosopher Ronald Dworkin, who's one of the people responsible for teaching me jurisprudence, he makes the point that there are no such things as plain facts or plain meanings in the law. So when a judge is a literalist, they are often engineering a rather conservative outcome. The Americans have a phrase for it in constitutional interpretations, peddled by a guy called Harlan, called strict constructionism. And strict constructionism or literalism in interpreting a statute or interpreting constitution favors the interests of the state and the powerful, because the legislation is often engineered in favor of the interests of the state and the powerful. We're not going to read anything into this to create any form of just outcome. The alternative in decline approach is broader purposive. We look to the objectives of the statute and what it's meant to achieve, and if necessary, we add words in to accomplish a more socially just outcome. Such judges who do that, who twist and bend, are often accused of being legislators. And it's been a common critique of any vestige of liberal judge in America now that they're accused of being a legislator if they adopt this approach. And since the conservatives basically have wrapped up the game in judicial appointment structures throughout the United States of America, not so much in Britain, but certainly the case in vectors of the Irish judiciary as well, then liberalism has become like a term of abuse. In fact, in our switched universe, anyone who's moderately off-centre or moderately centrist or even moderately conservative has now become a communist or a legislator if they adopt something like the broader purposive approach. The third rule of statutory interpretation is rectifying what might be called the mischief of the statute. What was it designed to resolve or solve? Always been an exceptional course of interpretation. But in constitutional doctrine, which leads to the article I wrote in the Bar Review, which I just cited in a book recently, and it came out in various forms, you have this really very sinister thing which goes hand in glove with literalism, called historical interpretation of the Constitution. And you've really got to understand how this plays out. It's invented, it's called the doctrine of original intent. And it's invented by a huge progenitor of the neocon and neoliberal agenda called Robert Bork, who was an American judge, who taught in the most conservative university in the States, Chicago. And Bork is responsible for two, let's call them innovations. Both ultimately at the time prevented him from being appointed as Supreme Court judge. Now I think they'd be a big asset. One is this doctrine of original intent, which is we interpret the Constitution of America, and you see people arguing it for it in other constitutional texts, in accordance with the intention of the people who drafted the Constitution in the first place. In America, that means we go back to what they call 1789. And this is truly sinister because you had the late Antoine J. Scalia, or Tony the Phony, adopt the historical method of interpreting the Constitution in America to legitimize the use and possession of handguns. Because if you go back to 1789, the lads had muskets when they fought against the British. Now, this is ludicrous stuff. First of all, it makes no sense. Why should we care about what people 200 years ago thought? It freezes the text of the Constitution in time. It's ruled, as Dworkin put it, by the dead hand of history. But that's too trite and simplistic a response. There is a clear agenda of the people who use the historical approach. What they're really trying to do is move times backwards to an old world society that favors their new interests.
It's the same like religion.
Well, I think it's the same as
the Bible.
Well, it's a return. It's a return to a kind of feudal class system, and a return to a form of social primitivism, and a return to the espousal of family values and that kind of thing. So, using this doctrine of interpretation, they are trying to push the wheel backwards and doing it very successfully. I mean, and the article has had a very favourable reception in some quarters, but I would imagine people who disagree with it realise quite quickly, which is true, that I oppose that literal historical agenda. Not that it's going to mean anything in terms of anybody being appointed to any position of institutional judicial authority, certainly in Ireland or the States, who does oppose that agenda, because it's not going to happen anymore, because there's an inevitability to this conservative agenda controlling the discourse. The other thing Burke was responsible for, which is even more extraordinary, and kicks in, well, in Chicago, he argued against and ultimately lobbied indirectly and directly successfully for not breaking up big trusts and big corporations, which is, of course, part of always the liberal, in the traditional L sense, American agenda, right back to people like Nader and those who oppose the interests of big business, and those who wish to break up the oligopical capitalism we now have. Now, which is destroying the planet, the cartelization of wealth into all of them. And Burke very successfully lobbied about nothing wrong with corporate monopolies. And of course, monopolization, it also favors the interests of the rich and the powerful. They don't want to open up competition. They want to restrict competition. They want their cartels to prevail. And Burke successfully argued for this. So he's a deeply sinister human being. That has led to, in America, even bizarrely, the protection as a constitutional right under freedom of speech of corporate speech, most recently. Now, other jurisdictions and the European Convention are not as favourably disposed towards the protection of corporate speech. But we've got to understand what the protection of corporate speech therefore means. It means giving legitimacy and the same level of speech protection to advertising, bullshit, salesmen, hucksterdom, lies, disinformation, post-truth, and all the bullshit that goes on with it, which favours the donors to all the major political parties of America and other countries in the world. So I think it's important that these doctrine, literalism, golden rule, historicism, you've got to destructure them and understand when a judge uses literalism or historicism, they're doing so to favour a certain interest group. And that interest group is, in effect, the corporatocracy and big business. And the other point is whether any of this stuff really matters at one level. Certainly, I'm very influenced and always have been and restrained in the legal realist school of thought. And I've written a paper on Jerome Frank, and I wrote a paper on judging thing that I wrote for Cassandra Voices. I also spent quite a lot of it dealing with Jerome Frank, who was an American legal realist scholar. And at the time, he said things a lot of people thought were subversive and slightly mad, even though he was a judge, which is that rules lawyers are used to thinking of law in terms of rules. He said, fuck rules. I didn't quite put it in those terms. But to echo another realist, rules are merely pretty playthings. It doesn't matter what the rule says. What matters is what are the judge's prejudices or biases which condition the outcome of a case. Now, he confined his analysis to trial courts. And anyone who's ever appeared, as I've done, a criminal case or a family case, will know that the outcome is determined not by the literal rules of the statute, but by hunches, prejudices, conditioned outcomes of judges and juries, when we all have prejudices. And Frank's thought unsettled the whole architecture of jurisprudence as a subject. I mean, when I gave a paper in this in Trinity, I remember them all being horrified by this, because they're used to thinking in this positivistic way of law as a system of rules. You apply this, you apply that. Well, not necessarily. If you're walking in with a particularly unsavory client before a judge who doesn't like that type of person at all. I mean, I remember I represented the Anti-Austerity Alliance in Dublin, and the judge said, well, I don't like them coming to my door. But, what's the rule got to do with it if that's the consideration process? And at least in fairness to him, he was upfront with his prejudice in this context. So I think, as an expansion, you've asked me to do it, of my career as a lawyer, is the obstacles you as an advocate face in trying to get a judge to reach a substantively just outcome against the hurdle of their innate conservatism and prejudice, their tendency to approach a literal or historical approach. And the literalism is always the easy way out. The other techniques they use are things like, I'm not getting involved in that, that's a matter for the government, separation of powers. Now, separation of powers has become like a mantra. It's bullshit, really. What it means, in effect, I'm stitching you up and I'm not granting you rights because the government told me to do so, and because I want institutional self-protection in my job, or because I've defined my job in such a way of innate conservatism. This has interpretively caused a nightmare in Ireland, where the judges for many years had the option, as Canadians and Indian judges have done, of creating some form of right to housing, or at least getting the government to get their finger out, and some measure of protection against arbitrary eviction processes. But they haven't done so. Now, they could do so by interpreting Article 45 of the Constitution or by reading an unspecified right in, but they don't. That's a matter for the government, a matter for Leinster House rather than the Four Courts. That's the Irish Parliament. A matter for us, or not a matter for us. And that's one way they filter out claims. The other thing which is happening in Ireland and America as well is the control of the docket. This is deeply sinister. It's undermining the whole litigation process. It doesn't exist in Britain, thankfully, to the same extent. There are appellate structures. But once you give American judges like potpourri, we'll take this case or we won't take that case, and now the Irish Supreme Court, you're getting them into the mindset that they can say, we're avoiding that like the plague. We're not dealing with that issue. And they also have other techniques of interpretation to avoid dealing with arguments of substance and merit. Locus standi. You don't have standing to litigate this. It's a class action. You're representing your cause, or, well, what the hell isn't really, in a way, or finding some sort of procedural statutory time bar or some sort of reason to knock you around. So I think, in terms of my career as a lawyer, an addendum to that is that an advocate who's a rights-driven lawyer has to go up against judges who use all of these techniques of interpretation and blockage, increasingly more so in a conservative way, to suit the interests of big business, the corporatocracy, and to undermine the case of the little guy. And last point, those great liberal judges, Britain's Denning, Holmes arguably in America, Douglas in America, there were some isolated examples in Ireland, all the great crusading liberal judges are now relics of the past.